Almost there. Yes. Almost there.
Yes, perfect. Good evening. We are really glad that you were able to connect to this discussion, the discussion of this evening about law and artificial intelligence perspectives from Europe and Canada. Before introducing the two speakers of today, I just would like to to underline the fact that this session, this webinar, is organized in the context of the Artificial Intelligence Belgian Week. That is a quite important event everywhere in Belgium, because all the community and all the people who have an interest in the developments of artificial intelligence can participate to different kind of events and discussions and lectures. And this particular debate is very important for the university, at least for the University of Brussels, both Flemish speaking and French speaking, because this conference is organized in the context of the official launch of the AI for the Common Good Institute. That is a joint project of both the ULB and VUB. It's a pleasure for me to present the speakers of today that will develop and try to present in a very in 30 minutes, each of them, the major questions around law and artificial intelligence, and share their views, and I hope we will have a lot of discussions about that, on the future of artificial intelligence regulation. After the presentation of Mireille Hildebrandt, we will have time for questions, and then we will start with the presentation of Catherine Regis, and then we will have a general discussion about the topic. So let me present briefly both of our speakers. We will first have a presentation by Professor Mireille Hildebrandt. Professor Mireille Hildebrandt is professor at the VUB. She is director of the Law, Science, Technology and Society Research Group, and she has published one very important book recently, that is Law for Computer Scientists and Other Folk, published at Oxford University Press in 2020, and I really recommend all of you to read it. And we have also the pleasure to welcome Professor Catherine Regis from the University of Montreal. Professor Catherine Regis holds the Canada Research Chair in Collaborative Culture in Health Law and Policy, and she is also an associate academic member of the MILA. The topic that she will address today is connected to a paper that she published at Springer Verlag, that in the name of the paper is Analyzing the Contribution of Ethical Charters to Building the Future of Artificial Intelligence Governance with Lise Langlois in 2021. So after having presented the two speakers, I will give the floor to Mireille Hildebrandt, just to mention that for those of you who have questions, you need to put that in the YouTube and they will be addressed later in the discussion. Mireille, you have the floor.
Thank you very much. I'm going to share my screen, and at the last minute I thought I need to add a hyperlink to my slide, which I now just did. And here we go, sharing the screen. Please tell me if it works. Can you see the PowerPoint?
Yes.
That is very good news. So the topic that I want to discuss today is robust AI and robust law. Robust AI is a term of trade. It's a way that computer scientists discuss what others might call reliable AI. And I want to see whether I want to dig out a bit what within the domain of AI, how people understand robust. And then I want to dig a bit into what robust law would mean and what that means for the relationship between law and AI. As you know, this is under the heading of FARI, the new institute here in Brussels. So I'm very proud and happy to be presenting on behalf of one of the two universities that are collaborating during the launch of this institute. So I want to discuss actually very simple 4 things: robust AI, robust law, AI under the rule of law, and then move into very briefly into the European situation, paying attention to the GDPR and fundamental rights. And I hope that that will raise a lot of questions. I've added just now a hyperlink to the webpage to the project, the ERC Advanced Grant that I have been awarded. It's a project called Cubicle that stands for Counting as a Human Being in the Era of Computational Law. I wrote a blog on that website about robust AI that will be followed up by 2 further blogs, one on robust law and one on what happens when AI is integrated into the law. So let's look at what is robust AI. The question here is actually first what an AI system is claimed to do. So when a service provider, an individual person or an organization buys or uses an AI system, and that can be anything from a smart car to a smart home application, when that party buys or starts using such a system, then it will expect a certain functionality, and that functionality will also be offered by whoever is selling it. And when you are trying to develop robust AI, because that's very much something that keeps developers on their toes, is 2 questions about whether that functionality is prone to break down if it is confronted with changes in the environment. And of course, those changes can be foreseeable or they can be unforeseeable. And we can also simply have attacks against such a system, and those attacks can be foreseen or unforeseen. Think, for instance, of adversarial machine learning, which enables to disrupt image recognition systems that in the first instance seem to have an accuracy of, for instance, 89%, but by changing 1 or 2 pixels in the image, the system suddenly gets it wrong in a way that is totally unexpected and in a way that a human being would not get it wrong. If such image recognition is used by a car or by a plane or by other hardware, robots, Internet of Things stuff that are navigating an environment, then such attacks could be in the real world environment of a system, can cause all sorts of disruption of AI. We can talk about resilient AI. That basically means that the system is flexible in the face of the disturbance. That means that it can bend and will not immediately break. The difference with robust is usually, because these terms are defined by different people in different ways, so they partly overlap. Robust usually means that the system will not bend so much, but is capable of withstanding perturbations. And if we're talking about complex systems, withstanding those perturbations by changing the inner workings of their system. So they remain the same by changing the internal operations or the internal structure. Now, resilient and robust can be understood in a very technical way, but now let's move a step towards reliable. Reliable is much more about how the system will behave in the real world when people are actually relying on those systems. And that means that reliable means that it behaves, or more importantly, it will behave properly based on reasonable expectations. And that term, reasonable, is of course very important here. For a computer scientist, a term like reasonable is a very difficult term because you cannot easily disambiguate it. And for instance, a lawyer, a term like reasonable, the fact that you cannot easily disambiguate it, that it has a rich meaning, that it can adapt to the context, is an advantage, not a bug. So here we're already moving out of the technical sphere into other spheres. The last R is the R of responsible. And that moves again one step further and says, okay, if we introduce this new type of artificial intelligence applications, or even infrastructures, what could be the potential adverse societal effects? And a system is reliable if those effects, and we're talking about potential effects, that could be a whole range, whether they have been addressed. So whether they've been mitigated already at the technical and increasingly, once they are being pushed out, made available, put in the market, also in the organizational sense. So let's go back to the technical level and ask the question how you could make robust AI. One way that computer scientists would do this is by way of verification. Verification is a mathematical way to basically try and prove that the system does what you claim it to do. That means you first have to make a model of the system, a model that you can actually verify mathematically. So there are steps. You make a model and then you conduct the mathematical verification. And in the case of complex systems, it's very important to make and to verify various models of the same system, because a model obviously is not the same as the system. So you always have to take a certain perspective, in a sense, a certain bias if you want to make a model. And the more important the impact is that the system could make, and the more complex the system is itself. Of course, many applications integrate different systems that will interact with each other. The more complex it will be to make a model, and the more important it is to make more models. Now, this is all about mathematical verification. So proving mathematically that a system will do what you are claiming that it will do. What happens, as I said, we're working here with models. So in the end, we're never sure what's going to happen. if you put that system out into the world, because you can't put the model into the world, because that's a piece of math. So we have another type of testing, that's validation. That means you deploy the system in the lab to test its behavior. The lab means you can keep the environment stable. You can you can keep certain parameters stable so that you can do some experiments with the system. But of course, for application like robotics, Internet of Things that are moving into the physical environment of people, it's very important to do empirical testing in the real world because you want to know what does a system do in a world over which you do not have complete control. Now, how are we going to make AI that is reliable, robust, resilient, and responsible? Robust and resilient, so you do verification and validation, and then it becomes very important, I repeat, to do that based on different models, and to always also put it out, so to model the environment of the system. Because how a system behaves, even within mathematics, will depend on how its environment responds to its behavior. So you need to develop and test different models, and do that while developing different models and test them also of the environments. Reliable and responsible means that you have to check the conformity with legitimate expectations. And moving from reliable to responsible, we are going to look at the legitimate expectations of all the people that count. And that means I'm now going to move towards the question, what is robust law? How does that relate, for instance, to democracy? It might be that a system is in conformity with legitimate expectations of all white people, but not of Black people. We've seen that with image recognition, where Black people, and I see this coming by on Twitter very often, that in a situation where a Black person sits in front of a screen, that they have to do all sorts of things for that screen to recognize them. I've read this, for instance, seen it about proctoring software that has to test whether somebody's cheating during their exam, right? So reliable and responsible goes beyond the simplistic technicalities and has to take into account a lot more. Now I'm going to dig a bit deeper. I'm going to take a step back when we move towards robust law and ask the question, why do we actually have law? Why don't we use other systems than law to achieve the things that we want to achieve as a society, to order society? And there are many answers to this. I'm just going to pick out three major goals of the law, three goals that interact and that are not always easy to satisfy in the same situation. They're not always compatible, but a system that claims to be a legal system, you could test that by checking whether it is aiming to satisfy those three goals. The first goal is justice, and justice understood as treating each citizen with equal respect and concern. This is on behalf of the government. We cannot expect all citizens to treat each other citizen with equal respect and concern. That's simply impossible. But we certainly expect that from a government because of the principle of equality. Now, treating everybody with equal respect and concern is a bit more complex than you might think, because there are two questions here. When one person, for having committed a certain offense, is sentenced for 6 months into prison, then we want the next person who does the same thing to also get 6 months in prison. We call that distributive justice. So we say for the same sort of cases, we give the same sort of punishment or We could also talk about compensation or whatever in private law. But there is another question, and that is whether there is equivalence between the offense that was committed and the 6 months. So why 6 months? So that's another type of justice. We do not want that somebody who stole a piece of bread because they didn't have anything to eat to get the same sentence as somebody that murdered somebody, right? So this is a different kind of equivalence called corrective justice. For a legal system to achieve the combination of these two types of justice is a challenge, of course. The second purpose of law, not very difficult to explain, is that the law is an instrument to achieve policy objectives that a government has. The important thing here is that those policy objectives should be achieved within the bandwidth of law. So law is an instrument, but it's more than an instrument. The idea is that the way these policy objectives are achieved matter. The third very important goal of the law is legal certainty. We often call that positivity. That means that we know that if certain legal norms are valid norms in a certain jurisdiction, that we can count on them actually being followed, having legal effect. That is connected, of course, with the monopoly of violence, but we're not just talking about brute enforcement here, we're talking about the law. One way of saying that is to talk about the performative nature of legal effect. So law is very much about attributing legal effect to a situation or an action. Let's go back to the same example. So if you committed murder, then the law attributes a certain legal effect to that. And that legal effect actually is punishability. That means that it authorizes a court to punish you with a maximum sentence of whatever it says in the criminal code. And that's a legal effect. It's nothing to do with causality. The law doesn't cause it, it attributes it. And their law is a different animal from other systems of coercion, for instance. Of course, the fact that equal cases have to be treated equally also provide for legal certainty so that you can foresee how your behavior, what sort of consequences it has, and it enables everybody to plan the rest of their life. Saying the same thing in other words, the law is about the stabilization of legitimate expectations. So we may not always agree on what could have been expected, but therefore we have a legislature, public administration, and courts to cut the knots, because at some point it may be more important that everybody can go on with their life than that we keep on discussing whether something is or is not a legitimate expectation. So law is very much about coordination. For instance, economic markets are constituted by the law. Contract and property, of course, they don't grow out in the garden. They are legal constructs, and you can construct them in different ways. So how an economic market functions, that's again a form of coordination, depends on how the law does that. And of course, an important function of the law is peace. We are used to having a monopoly of violence, which is not the same as brute force, as I said, but of course it has a lot of consequences. That also means that law is something different from ethics. It's also something different from politics. Law actually depends on the rule of law. Monopoly of violence may suggest some sort of absolutism, as if the state can do whatever they want. Somewhere in the 16th, 17th century, we invented in Europe, it's a historical artifact, the idea of the rule of law as an internal division of sovereignty. So we said legislature, administration, and courts should be constructed as countervailing powers. It should be clear that the law is both about closure, about at some point making confusion about what is and what is not validly legal. There has to be closure, that is legal certainty, but the contestability is also part of legal certainty. The concepts of the law, they are defined in natural language, not in computer code. That means they can be articulated in different ways, interpreted in different ways. And while some people might think that's a bug, it is actually a feature, because it means that people can contest this in a court of law. There will be discussions, there will be a second instance, and at some point there will be closure, but based on sound argumentation. So contestability implies the interpretability and understandability. So robust AI is all about testability, verification, validation, different types of testability. Robust law is actually, to a large extent, about contestability, because contestability makes things more robust. So that means that we need a legal framework if we want to have AI systems under the rule of law that obligates developers, manufacturers, operators, and providers to manufacture, develop, operate, provide, etc., resilient and robust AI that will concern, in terms of the law, issues of conformity. That's private law, that's about contracts, and safety, that's you're already moving towards private law liability. At the same time, we need a legislative framework that obligates all those involved, developers, manufacturers, operators, providers, to offer both reliable and responsible AI. And beyond private law liability, which is very important for safety and conformity, that will require AI behavior. So the prediction of how, or the foreseeable way that these AI applications are going to behave, that has to be fundamental rights proof. And it's very interesting that in a European context, that on 14 December, the Fundamental Rights Agency connected to the European Union presented its report, Getting the Future Right, Artificial Intelligence and Fundamental Rights, where they actually took the position that those who put AI applications or systems or infrastructure on the market or make it available in another way should do a fundamental rights impact assessment. And it's very interesting that they speak of an impact assessment and not a risk assessment. It'd be very interesting to go deeper into that, but I don't think we have the time for that. Let's have a quick look at the GDPR. So many people, especially outside Europe, think the GDPR is a privacy law. I would object to that. I don't think it's a privacy law. It's much more interesting than that, though privacy is certainly one of the focal goods, public and private goods, that are protected by the GDPR. And many people think that the GDPR is only about data subjects, so that it gives certain rights to and imputates obligations in relation to data subjects. That is the person, the natural person whose personal data are being processed. The GDPR, however, looks far beyond that. And I think that's very good and very important. And that is why the GDPR is very relevant when we're talking about AI. So in Article 1, which basically gives us the scope and the objectives of the GDPR, the GDPR says that it is meant to protect the fundamental rights and freedoms of natural persons. In Article 25, the GDPR says that whoever introduces new technologies that might pose a risk for natural persons, for the fundamental rights and freedoms of natural persons, has to embody data protection by design into their systems. Here again, what is interesting is that Article 25 doesn't talk about privacy or only about data protection, the fundamental right to data protection. It talks about the protection of fundamental rights and freedoms, and it talks about natural persons, and that's very important. Why is that so interesting? Well, that means that if you are processing personal data of a whole lot of people and then infer knowledge from that, that knowledge is probably not personal data, but you might then apply that knowledge to others, to natural persons. And what Article 25 basically says is you have to take that into account. So the fundamental rights and freedoms of natural persons that might be affected by the knowledge you infer and by the sort of decisions you might take regarding them. Think of bias, think of non-discrimination, but there are many other rights at stake, like due process, fair trial, presumption of innocence, etc. Article 35 does the same thing for the requirement to initiate a data protection impact assessment. Again, it's about protection of rights and freedoms, not just data protection, and privacy is not even mentioned, of natural persons. So again, we look forward. And actually, this is what I want to say at this moment, and I'm going to stop screen sharing, and I'm looking forward to your questions.
So thank you very much, Mireille. We have a first question, and the question is the following. Is using AI to circumvent, is using AI to circumvent the scan car functionality a fundamental right? The current fight between the city of Amsterdam and the app Per keer wekker about the scan car city of Amsterdam count uses scan car that looks in AI at license plate and then issues a parking fee or not. Parkeerwekker uses AI picture recognition of, and I'm waiting for the...
Yeah, that's a bit of a difficult question because I'm not sure what this is exactly about. So there is, of course, not a specific fundamental right to circumvent scan card functionality. The question is probably whether circumventing of such a functionality would be a fundamental right. To answer that question, I would have to look more properly into it. This sounds like algorithmic decision making, right? So there is an automated decision about when you get a fine. And I think that all these type of decisions, depending on, we're talking about a fine, that means that Article 6 of the European Convention of Human Rights applies because it falls under a criminal charge, because the definition of a criminal charge in the European Convention is autonomous. So even if the government says this is just an administrative fine, the court will say in terms of the convention, this is a punishment. So you can start by saying that the right to a fair trial, that means you must be able to appeal, and you must be able to appeal to an independent court. Even Article 7 might be applicable, which is the presumption of innocence. I think a large part, I happen to be Dutch, so of the general law, the General Act on Public Administration, protection against public administrative acts, would be applicable here. To cut it short, yes, I think there are more than one fundamental right at stake here. And I think it would be very important to be able to know more of the details, because law is not there to make general statements, but to look in the particular context and to say, okay, that and that are your rights that you could exercise.
Okay, so thank you, Mireille. There are other questions, but the idea is the questions are not directly connected to the main, the core claim that you have made, so we can keep them for the discussion. And so I will immediately give the floor to Professor Catherine Regis.
Okay, hi.
You have the floor.
Yeah, thank you. Thank you so much. So I'll try to share my screen, and if there's a bug, please tell me. Okay, can you see?
Yes.
Yes.
Good, okay. And let me know if it doesn't change slides, since it happened to me recently. First of all, I just want to say thank you for the invitation. I'm very excited to be here. A special thanks to Karl Mork, with whom I had the pleasure to work with when he was in Quebec. I'm very sad he left, but now it's exciting because we can collaborate from 2 different countries. So what I want to talk about today is on building the future of AI governance, and really explore the intersection between law and ethics. And usually the work that I do is mostly focused on AI in the healthcare field, but I became very interested by this interaction, general interaction between law and ethics. First, when I started to work on the Montreal Declaration for Responsible AI, so I was involved in this team who built the declaration, and I had to work with ethicists, but also the AI community more broadly. And I became quite fascinated by how they saw the law and some perception that they had about the law. So do you see that slide as well?
Yes.
Okay, great. So now it's working. So just to give you a few examples of what I often hear, and that's surprising from a legal perspective. So one example, and I hear that very often from ethicists that work in the AI field, so they're quite connected to the reality of this field, is that ethics is all we have now. The law does not regulate AI. They have this surprising idea that there's no law right now, and we currently live this world where ethics is the main normative scheme that we have. So my reaction to that is, what? Of course, there's a law, something that is pretty obvious for our jurists, but it's not for the broader community. So it's something that we need to take into account, but the law hasn't disappeared. It's just sometimes we don't know how to apply it. And the next step is how we should really implement further legislative disposition that really makes sense with the AI reality. Another example of what I hear is that mostly from the AI community, which makes sense because they're used to a very different pace of evolution, is that legal developments are so slow and they're very annoyed by this. And my reaction is, well, it's true, but it makes sense from a legal perspective. And this is somehow connected to what Professor Heiler-Brandt has mentioned before. And one of the reasons is the legal predictability. It's important that the law doesn't change often, but when it changes, it makes sense. So people can adjust their behavior accordingly. Another thing that I hear often from the AI community is they are kind of mixed up between all these norms, like law and ethics. What's the difference? Norms are norms. And of course, there's a difference, and I'll explore that a little bit more later. But my reaction is, yeah, there's a difference. Enforcement capacity is one of the main differences. But I think the question is very interesting. And this is something that the legal community kind of had to clarify with the AI community. So the objective that I have for this talk is to think, what can we learn? The first question I want to address is what have we learned and what can we learn so far from ethical charters and principles in AI? And the second thing that I want to address today is, can we build on such charters and principles to adapt legal frameworks? Oops, okay. So the first question, what have we learned so far? And I'm going to explore a bit of the good, the bad, and the ugly of ethical charters and principles. The conversation could be much deeper than what I'm going to do today, but just to give a few insights about this point. So there's been a very flourishing developments during the last few years on the ethical charters and principles scene. We saw more than 84 guidelines and 36 charters just over the last few years. And this is a great contribution because it has sparked crucial conversations around the world and led to some formal positioning from different stakeholders, academia, governments, industry, and so on, regarding what good AI means. And sometimes a formal positioning took the form of administrative directives, sometimes guidelines and other modalities like that. It also contributed to democratizing the access to AI information and debates. Some of these ethical charters, for instance, the Montreal Declaration, involve different stakeholders and citizens in the development of the instrument. So that's an example. And also the charters have contributed to the emergence of a normative core based on the proportion of convergence of all this normative ethical work that has been done. So we can have now a clearer understanding of what matters internationally wise. But despite this galvanizing effect of such ethical initiatives in AI ecosystem, we have started to see kind of an opposing movement more recently. That movement is often called the fake ethics or ethics washing and bashing. So that can be defined as the trend to discredit or trivialize AI ethics in general and governance initiative in particular. And there are different sources for such phenomenon. I'm going to explore two today. One of these sources is the nature of the group undertaking the development of AI ethics charters and principles. For instance, when a few research work discovered that when we go deeper into these charters and principles, we can see not for every charters, but still it's an emerging fact that industry lobbies intend on delaying the implementation and development of AI regulation and policies by really pushing for the development of charters and principles driven by ethics. We also saw that the composition of groups of experts were sometimes politically driven and not always fairly representative of various groups, such as gender representativeness, sectors, discipline, countries, and so on. We also saw that sometimes a minimal number of ethicists compared with private sectors representative composed the team that work on these tools. And sometimes also they were used more as marketing strategies for some organizations, and the interest for ethics was weaker somehow. Another reason that explained that kind of resistance towards ethics that is emerging right now is the practical gap issue. And that one is especially interesting. So we realize that ethical principles sometimes do not easily translate into technical solutions, especially for developers. And that's something that starts to frustrate the AI community. So 79% of technology workers want more practical resources to help them with ethical considerations. So they know they have these tools, they want to apply them in many occasions, but they don't know how, and they kind of become frustrated by that reality. So we kind of need to embark on a more practical endeavor to move from the what to the how. And if we don't do that, this can lead to the rejection by the technical and AI user community to valuable ethical benchmarks, and also create kind of a gradual disinterest in future conversation about ethics. So lack of interest towards future AI, responsible AI, and ethical conversation. This is what we can call ethics shrinking. So for charters to go beyond their declarative purpose, like the good intention behind these charters, I think they must overcome the challenge of implementing the principles they encompass. And here I think the image of the golf ball is quite revelatory. We just need to kind of hit the ball and see where it goes and what's the problem and where it works, when it doesn't work, and kind of adapt to this reality and reduce the practical gap. And for this, we need to embark on the formalization process of ethical charters to really look into the social regulation tools that they can be to transform, for instance, professional practices, processes, and organizational systems. For instance, through internal mechanisms within organizations, modes of management, and so on. And I think here the Montreal Declaration for Responsible AI is another example. So we developed this declaration. It's kind of an ethical compass to really guide the AI community. And it's composed of 10 principles and many sub-principles. And once we adopted this, we adopted this declaration, then the community said, well, now I want to apply it, industries, developers, and so on. And can you help us to develop tools to do that? So this is a journey that we are trying to embark on right now and really develop tools that can help the community. So the second question I want to address in this talk is, now can we build on such charters and principles to adapt legal frameworks? And I think the formalization of ethics, the thing that I've mentioned just before, could also be explored with respect to its potential to develop AI regulations, either locally or internationally. And I think that at this moment, we kind of have this consensus or stronger agreement that the next big step in AI normativity is really to add additional binding norms in this ecosystem. Why? This next step is considered to be the major normative step. We realize that the limits of ethical charters and principles, I mentioned some of those earlier on, but also we realize that it's very difficult to only rely, which makes sense, right, on ethics to regulate powerful industries. We even, if you recall, there was a recognition from the Google CEO in January 2020 that self-regulation is not enough. We really need to embark on this binding norm journey. Of course, we can discuss that. There are many interests involved in such a statement, but anyway, there are also well-known scandals that now we realize we really need to have this binding environment where we can kind of play from equal arms with what is going on in the industry, for instance. Also, when we built the Montreal Declaration, we also had a policy report that kind of was produced with the Montreal Declaration, and it really is people's most wished option for policy options to really to implement in the footstep of the Montreal Declaration. And the demand for additional legal protection came up as the policy option most required by stakeholders. Yet, this doesn't mean that we don't have regulation for AI, as I mentioned at the beginning, something that I often hear in the field. Criminal law is still there, tort law, contract law, and I think Professor Hildebrand really mentioned that well during her talk. But still, we have some blind spots or weak spots for legal oversight, or we also insufficiently tackles right now from a legal perspective some of the novel issues that AI raises. For instance, a lack of transparency and explicability. Also, better understanding the legal hazard, whether they are real or perceived, is an obstacle to innovation. So this is something I realized during my research, but there are other literature on that, is when the innovators are not sure, or the actual end users of innovation are not sure about the legal risk that the innovation entails, they hesitate to apply the innovation. So, and this can create a gap between the actual development of innovation, AI innovation and other type of innovation, and the actual implementation in the field, with a lot of lost opportunities and money as well. So there's a need to clarify legal frameworks and responsibility issue to kind of enhance this legal predictability that Mihai also mentioned. Yet we were kind of slowing doing that because legal developments usually requires a certain maturity in understanding social phenomena. And I think ethical charters and principles have been very helpful here. They contributed to significantly make clearer the AI risk, benefit, and challenges. This is something very useful on which we can build now to move forward with legal developments. I also think that charters or principle, like ethical charters and principle, were able to shape individual and social expectations toward technology and kind of counterbalance, more than a law could at least at the beginning of the movement, the strong normative effect that technology has, right? When technology is implemented, it really kind of becomes, by using it, kind of ingrained in people's habits and what they can expect, right? We all use our iPhone or whatever phone we have, and it's kind of part of who we are, and we cannot imagine a world without using our iPhone. So the technology creates this rapid normative effect. And I think the charters and the ethical principles and all the conversations that was going on during this rapid AI development kind of counterbalance that normative effect and created another discourse where people now expect more different kind of norms and a broader shaping of this AI ecosystem. So it also made clear that governments and big actors cannot stay still in the face of this strong development movement. We need to act, we need to take a strong position and redefine our normative goal in this area. The charters and the ethical principles were also able to target priority areas of normative action. This is useful, and I'll come back to that in a few minutes. And now I think the law can build on these valuable ethical assets to better target regulatory options. And today I'm going to talk about very briefly two options for legal development based on ethical charters and principles. First, we can develop legal regulations based at least partially on these ethical charters and principles. So really use the principles that we have in some of these instruments and see how it can correlate into a legal obligation. Of course, this would require adjustment as law needs to operationalize its normative postulate to make sure that it's enforceable, which is not always a concern for ethics. So that translations need to be made. Also, the formalization of ethics will be useful here, at least partially. So that process where we kind of test our ethical charters in the actual field and see whether it works or not, and have kind of that feedback loop where people say, well, that doesn't make sense in my enterprise, I cannot really apply this, or the AI tech community can also send that message. That kind of creates an applicability test for what works or not normatively wise, which can be useful for the law, considering its the enforceability consideration. Also, some ethical principles that are ingrained in these instruments are more easily transferable into legal duties. For instance, some require human autonomy, human keep some autonomy in this big AI movement. Also that we have more exploitability. This is a reality or concern for the law. It has been for a long time. So this is a language that we better understand and we can really connect with some ethical principles there. Also, in some of these ethical instruments, ethical principles are often more granular than in others. So it becomes easier again to really build on these more specific principles and to trying to define a legal duty that could correlate to that, or not necessarily correlate, but be inspired by that. And there are examples of work that has been done in that kind of translation from ethical charter principles into actual proposition of legal modification. So this has to continue. And I give an example here on the slide. The second thing that we can do to really build on these ethical work to move forward with further legal developments is use the opportunity that they provide for an international scaling up of AI normativity. So ethical charters could be a valuable asset to expand the normative landscape at the international level, whether we go for binding or non-binding norms at the international level. Because these ethical charters come from different countries, as I mentioned at the beginning, even if it's not perfect, but still it has started to really create this international kind of evaluation of what matters for people in AI. There's also a clear need to develop collaborative international governance tool. This has been mentioned by the UN high-level panel on digital cooperation. We know that regulating AI at the local level is not enough. We really need to, because it cross borders this issue, and it really impact on human dignity, environment, and different concerns that are important for the international community. And also these ethical charters have, and I mentioned that at the beginning, but have started to identify points of convergence and divergence in AI governance, what we can call the normative core. So that normative core is the points that have been identified as more converging in all these tools. Someone has analyzed all the tools produced, all the charters, all the principles, and what are the diverging points, and what is the normative core, what is the converging aspect of all these charters. And I think that's a good start to use this convergence understanding of what is important to build the next step in international norms. And the clearer international convergence that has been identified pinpoint 5 principles that are more important to people and international communities: transparency, responsibility, privacy and justice, justice and fairness, and non-maleficence. So that's a good starting point, but it's certainly not a final endeavor. As I mentioned at the beginning, there are some flaws with these charters. And for example, some region or groups are underrepresented. So this is just a start, but it's a good start because it can have an accelerator effect, since building international consensus takes a lot of time and resources, and especially when developing binding norms in public international law, for instance. And starting there is a good way to accelerate that effect. So my conclusion would be that law and ethics can work together to develop a coherent normative strategy for responsible AI. Of course, they have different logic. They don't depend on each other, but they really can work together to have this more, not necessarily coherent, but comprehensive normative strategy. Law is more concerned about providing clear enforceable norms that apply to all, but ethics is more responsive to fast-changing environments in general, and can also add layers of reflexivity. So law is often what you can or cannot do, but ethics add this different dimension of what is the value of what I do and what should I do it. So to have the two together, I think it's a very interesting normative strategy. And the intersection of the two, where they can really build on each other, provide a normative guidance and opportunities that I think, if they are mobilized appropriately, can really amplify each domain's contribution to responsible AI. So if you are interested by this conversation, I invite you to read a paper I recently published with Lise Langlois that really discussed this in further detail. And Lise Langlois is an ethicist, and I'm the legal person, so it was kind of interesting to have this conversation in the paper. So thank you very much.
Thank you very much, Catherine. I suggest to stop sharing your screen so that we can have a real panel. We get quite a bunch of questions already, and I will try to go through them, at least for those who are questions and not only remarks. And one of the questions, and I think we can broaden the topic a little bit, is about the protection of. It's of course a very important question for people developing AI solutions. How can you protect intellectual property rights on methods used by people developing AI models? And this question, I would like to link that a little bit with the very surprising fact that with the development of AI and this huge topic, we have two very important things: data and let's say methods or algorithms that are used in order to explore data, and both of them are not protected by intellectual property rights. So I would like to perhaps have, if you have any comments on that, how can you do and why is that so complex to protect the methods used by data scientists from a legal perspective?
I see a lot of patents being applied for all the time by big AI companies. So as far as I understand, because I'm certainly not an expert in IP rights, maybe you are in a better position to answer that question, Gregory, yourself. But as far as I know, as soon as such a methodology, such a technique is embedded into hardware or connected or made dependent on hardware, you can move towards a patent. And I think in Europe, you have copyright. So I imagine that within the European context, most of these techniques can be copyrighted if they are not pure mathematics. But I think the question that I see here in the chat is about implementation, integration, so you can protect that. And I would actually find more interesting the question how that protection, which is invoked quite often, interferes with transparency rights. But maybe we should first answer the question.
Yes, so thank you. I know it's somehow a technical question. I think that we can have a private chat with the people asking this one. But let's move a little bit about the GDPR, because you, Mireille, extensively develop a very specific understanding of the GDPR, and of course, a lot of people are a little bit skeptical about the implementation, and we know that the life of the law is in its enforcement, and a lot of people are a little bit skeptical about the implementation, the concrete implementation of GDPR, especially as soon as it concerns class actions. So I think there is a question there about, okay, what about the enforceability? And and if I can broaden a little bit the question regarding what we can see at the European level today with the negotiation of the Data Governance Act, and you have probably seen that the joint opinion of a European Data Protection Board and European Data Protection Supervisor stating that, in fact, the Data Governance Act is probably violating a lot of the aspects of the GDPR, the protections provided by the GDPR. So what about the concrete implementation? And are we not, even in Europe, going in the direction of loosening the rights provided in the GDPR, which is a right for, okay, the data subject and protection of data, but also, and you do not mention this aspect, for also the the free movement of such data. And this is also in the title of the regulation. So what is your position? And perhaps, Catherine, we know that in Canada, you have also a lot of discussions about data protection. And how do you see what is happening in Europe from your perspective, including from an ethical perspective of the use of data?
Yeah, so we know the story about the non-enforcement of GDPR. That's a narrative that has been there long before, and it would never happen. Well, we have seen the Data Retention Directive completely nullified. We have seen 2 decisions of the Commission with regard to the transfer to the United States nullified. So I'm not so worried about that it's not enforceable. I think a good law has the right level of abstraction, and that means that its enforcement and its implementation depends on context and circumstances. And that's not to make everything very fuzzy and fake, but on the contrary, to make it more concrete. So when you see cases like Wirtschaftsakademie and Fashion Idea, and this is not the place to explain the details, but they go quite far in making those who build websites on top of certain social media or who employ data analytics while taking a sort of a moral holiday, saying, well, that's just very convenient, so we have nothing to do with the fact that all the data of the visitors of our site are now sucked up by big tech platforms, but it's none of our business. The court has basically said, well, it is, and you're going to be liable. About very practical enforcement from the data subject side, I agree that class actions are important. Article 79 imposes on the member states to give people the right to file an injunction. And Article 79 is part of Article 80, sorry about all the technicalities. And that means that people can mandate an NGO to file an injunction and to say, okay, this or that company has to stop processing unlawfully our data. For that, you do not have to prove any damage, because the issue is usually that people try to get a lot of money from companies. So they want damages in the case of a data leak or something like that. But usually that's very difficult to prove, or everybody gets €3, which doesn't really help. But if you can file an injunction, and if the court can say for every day that the company doesn't stop, it has to pay 600,000 or 3 million euros, then that will have a much larger effect. I think you had a second question, yes, and that was about the Data Governance Act and all kinds of interferences with the GDPR. It's clear that the EU speaks with different voices. I think we have to be very open about that, because we can all see it. So it's going to be very exciting how the countervailing powers within the EU, those who do not only want to innovate, but who have a near religious respect for and faith in anything that is data-driven, whether it really works, whether it's just exploratory and sold as confirmatory or not, that sector, how that will interact with the people who are a bit more cautious. My position is that when you look at the GDPR, especially the principle of purpose limitation, is going to make sure that we have robust AI in the technical sense, because it requires that before you begin all your fun exploratory research and put it out for everybody to use, you have to ask yourself the question about purpose. And anybody who knows anything about machine learning knows that you cannot ask a machine to learn anything until you give it a very specified task, even a formalized task. So I think the GDPR is on the side of robust AI, robust, resilient, reliable AI. So I think that the human rights aspect and the innovation aspect should be taken together. And we should not have the illusion that by throwing a lot of data together, that often come from different contexts, that are outdated, that where a lot of noise is around, and then doing something with algorithms, whatever, is going to be any sort of competition for the United States or China, because this is very much a geopolitical argument that is often suddenly thrown into the thing. So my presentation was about this. We want really good stuff. We don't want planes to fall from the air. We don't want our fridge to explode in our face. We don't want our daughter to be sent to the wrong school. And that's all about having stuff that is reliable, and that's related to explainability and comprehensibility, but it's also related to creating the right incentive structure in law. For instance, private law liability, strict liability if the risks are higher, to make sure that that the temptation to put out stuff with a lot of PR that has high accuracy but low precision, while it's taking individual decisions. I mean, anybody who knows anything about that knows that's a very bad idea. So I think the GDPR is good, but we need more. And I'm very curious how the Data Governance Act is going to be in the end.
So I will go to Catherine and perhaps to of course, beyond data protection and regarding AI ethics and the movement of AI ethics, there are different questions, and I will try to summarize them somehow. You have different aspects in the discussion. The one is, do you think, and that is, I think, quite a huge debate, it's not a new one, but it's, do you think that AI ethics can take into account the cultural differences and the geographical differences that exist in the world? Because they are, it's an old question that exists also in human rights law about how do you take into account in the development of this general AI ethics that we have everywhere. How do you take into account the cultural differences? And the second aspect of, and no, you can see that I think everywhere. What about the transformation or the building on the data, different data ethics and charters, etc., of some kind of certification about how do you organize the development of technical standards? Because basically in the world of companies, and it's something that we have seen with corporate social responsibilities, etc., you start from ethical charter, but then you have a process. And this process leads to a lot of different, very defined and precise management rules and internal process in order to guarantee concretely the respect of the charter. So what is your position about the different tentative to develop some kind of technical standards? And is that the answer that data ethics, AI ethics is bringing in Is it GDPR and law versus technical standards, or is it something different?
Okay, so thank you for the question. First, I just want to mention that I'm not an ethicist, so I'm very to go deeper into what ethics is not going to be my cup of tea. But I think now that I've spoken with a lot of ethicists, that ethics is very much in the business of being able to adapt to different cultural realities. It really is about that, right? So you have principle, but then you try to adapt them to your reality, your constraints, and so on. So I would say yes, this is something that ethics can do. Regarding your second question, if I understood it correctly, and this is something that I often hear, and I don't have the final answer for that for sure, is what is the role of all these different norms, right? You have ethics, you have law, you have certification, standards, and it's very interesting and makes our role so much more interesting when you think about norms and with all these aspects and try to see how they connect and where they need to be put in place to make sure that we have the most coherent and efficient, actually, normative strategy. So for me, the answer is, as I mentioned at the beginning, I don't have the final answer, but I think it's to see the puzzle with all these pieces is useful when you want to have a coherent normative strategy. And I think they address different realities or questions. And the role of standards or certification is certainly important and has a lot of impact as well. Sometimes this certification, if you have it or not, it will make the difference for you to be able to send your product on the market or have access to that market or be able to build on some public contracts and so on. So the certification is a very powerful tool for sure. And one is strongly, but not exclusively related to private interest, to the regulation of industries and so on. So that's for sure an important aspect. As I mentioned, the role of ethics, what I find interesting, and at the beginning I was really frustrated, like that, I don't know if it was like that everywhere, but it seems to me that the reflection on AI normativity was mostly focused on ethics. And as a legal person, that was kind of what's going on there. I mean, we have a need for binding norms in this environment. And then I took a step, out of this and tried to understand the contribution of ethics. And then it became very interesting. And I think that the law was kind of frozen at some point because law has this crystallizing effect. And if we had started with strong legal conversation at the really beginning of AI, I think it would have been limiting to the regarding the conversation that we had. So we were more able to explore, to really have more candor about how we express our concerns instead of sending that hammer with the law right at the beginning in the conversation, even if it was always there, but it was not dominant, at least from a Canadian perspective at the beginning. And then I realized that ethics was really contributive. That's what I mentioned in my talk, because it was able to act fast. It was able to really spark that conversation, to include different considerations that are not always relevant for law. Sometimes they are, sometimes they aren't. To include different people in the conversation, to really have this kind of being aware conversation and really engage on this normative path where the law is somehow at the end of the path. And the fact that law kind of define the minimum of what we have to respect, but don't really engage people in that, not necessarily engage people in that important reflection about, is it relevant what I do? Should I do it? Like, we develop a lot of technology, we develop a lot of AI that doesn't really make sense sometimes with the actual reality of people, the end users. So to really, that's not something the law will necessarily be concerned about, but ethics can do that. So that's how I see ethics. But then it became, I think we hit a wall, and I think that's good ethics, but maybe enough now. Let's continue to work there, but move on to the second layer, normativity, and really try to develop coherent legal strategy, efficient, but take into account this reality where we have other norms, and really to build on strengths of each of these norms to have a very useful and relevant strategy.
Okay, thank you. Yes, Mireille, because I think this is of course one of the I think kind of disagreement that you may have, you and Mireille. It's about the role and how much you can rely on ethics. Mireille, you want to say something about that?
Yeah, so no, I don't know if we have a very different position on this. I think we're both lawyers, so there is a need for law as a basic layer. And on top of it, I always say that law will enable actors, or law should enable actors to act ethically. If the law is such that if you act ethically, you're pushed out of the market, then we have the wrong legal system. And you can't go asking people to act ethically knowing that they will be pushed out of the market. So there I see a clear link between the two. But I wanted to respond to the idea that a lot of the AI applications that are put on the market that are PR'd towards, for instance, the police, social security fraud and tax fraud detection systems that are deployed everywhere, where we see a lot of things go wrong. Now, the fact that these systems sometimes are not really useful, I heard something like, well, that's not a matter for the law. But in Europe, both on account of the European Convention of Human Rights and on account of the GDPR, there is a necessity requirement every time you are processing personal data. And that's the GDPR, of course. So that necessity means that if it's just useful, but you could do this in another way, then you're simply not allowed to do it. And in terms of human rights, if the use of certain AI infringes human rights, and it could have been done well in another way, so if it's not necessary, and of course the law is quite nuanced there. It talks about necessary in a democratic society, and it talks about whether there is a pressing social need. There's a whole case law around that. This is not done in just one night, but the necessity is an important requirement, and I think that fits the bill. So as soon as these sort of tools are processing personal data, they will have to comply with the GDPR. That means that there will have to be a clear purpose. That purpose can be decided by the controller. It's not that there is a limited set of purposes then, unless there is also an infringement of human rights. So the necessity is a core principle in Europe. And I think that makes a difference. That's important. You can do whatever you want, but if you start harming people, there are certain restrictions there.
Catherine, do you want to react to that?
No, I think we will probably, okay, it's open. We would probably use the word proportionality here. But, you know, these addresses cases where there's probably a strong impact. And I totally agree with you, Mireille, for sure. But what I see in the field is that there's a lot of technology that are developed. And, you know, we call this the most inconvenient truth about AI, especially in healthcare, is what we develop and what we actually implement. There's a big gap. And what part of my work is try to better understand the gap between the two. Why is it that we develop a lot of things, but then in actual practice in healthcare systems, probably in Canada more specifically, but we don't really see the full impact of these technologies or the full implementation. And part of that is, as what I mentioned in my talk, part of the reason of that is the legal uncertainty. So some people, because it's so new right now, they're not sure if they use it, physicians, if they use it, healthcare managers, for instance, what's going to be the consequences of it. So that's one of the reasons that explain the gap. Another reason is, and that's the more nuanced aspect, the more less dramatic aspect of necessity that you're referring to, is sometimes people develop something without enough consideration of the end user. What we could say, what could be called the pertinent or intelligent by design. So they develop something that it's going to be fantastic for physicians, for instance, but then they don't realize that it's not the physician who's going to use, you're going to be using this tool, but it's going to be the nurse, because if he does, he has to wash his hands twice the time, and he doesn't have time for that, to delegate that function to the nurse. That's an example, concrete example I have in mind. So then you develop something that doesn't make sense in the actual reality of practice for these people. So that's what I had in mind in a less dramatic way of the necessity and the concern for the law of these realities. But Europe seems to be different in actually many aspects, for sure.
So we have still 4 minutes, and I would like to ask you a very, very last question to both of you, because we have discussed so far about informatics or AI, ethics and law, taking for granted that law is something that is not affected by the development, the digitalization of the world. And some people consider that because everything is accelerating, and because we have so many operations and so many information about what is going on outside there, we need also to change the way we create law and implement the law. Just to give an example, quite recent, you know that the OECD developed this idea of rules as code, saying, okay, what we need in the world in which we are living is really to create a kind of machine consumable law that we can apply, and the government will be able to give you really the code, the written code of the law that you will just plug in. And this is a very, very interesting perspective about the transformation of law. And recently, it was like in February 22, the Security and Exchange Commission even mentioned this, that one day we may have an easily machine-readable rule books that we can plug in, and that will integrate regulation inside the operations of the different systems. What is or what are your perspectives about this kind of ideas?
Can I share my screen?
Yes.
So this is actually, as Gregory probably knows, the subject of one of the research projects I'm leading. And we've just started a new journal, cross-disciplinary research into computational law. And the whole idea of the journal is to invite both computer science and law and people outside that who reflect on both, but especially lawyers and computer scientists, to start this conversation together. Because I'm not a technological determinist, so I'm not saying this is definitely going to happen, but I'm also not blind. It is happening. There is this wonderful thing called Westlaw Edge, which I've been studying in depth, which has a multi-annual contract with the federal courts in the United States, which is used by most big law firms in the United States, probably also by the public prosecutor. So their access to law is now mediated by the same system that does legal search, like we do search on Google. So as a lawyer, you do search in that. You can actually input as a lawyer your brief. For the non-lawyers here, that's something very technical in the legal sense that you prepare before you take your case to court. You can input your brief into the system and it will tell you, hey, you forgot these 2 cases. Hey, you shouldn't use this case because it will be used against you. You missed 3 arguments in the 4th case and you're quoting an outdated law. And because Westlaw Edge will be liable, civil private law liability, if they get it wrong, and because big law is using it and courts, it must be good, right? Let's assume that it's pretty good. There are some papers out there how they do this. So these things are happening. What you're talking about with rules as code basically means that instead of enacting a text-based law, you already at the moment of writing the law, also write that same law in code. And I think it's absolutely fascinating because then the next question is, when somebody has violated the law according to the code, and they go to court and they say, no, that's not true, and they point to the natural language, then what's going to happen? And the more interesting question for us, what is happening when a legislator is forced to articulate the law in such a way that a machine can understand it? And let's face it, machines don't understand anything. They can't. They do something else. They do natural language processing, which is extremely interesting and fascinating and fabulous, but it has nothing to do with understanding. So a court and a legislature in this case being forced to, imagine if you want to write a law and you want to say that the criterion is what a reasonable person would do. Well, sorry, but that law can't be written anymore because the computer won't be able to understand it. So you will have to begin to specify that into code. So it will have a major impact on the law. I see many drawbacks, dangers, changes of what we think is law. But I also think we can learn a lot from it, and depending on how it is done. Some of the, I think I just heard that the president of the Court of Strasbourg, so European Court of Human Rights, said today that they are going to use this sort of technology to sort the cases because they have a backlog of 16K cases. So fascinating, but very important to have this conversation between computer scientists who know the limits of computer science and lawyers who might stupidly embrace it all without understanding what they're doing, you know.
Catherine, what do you think about this transformation of the law?
That would be your area way more than me, but just referring to a conversation that I had recently, we're an AI technical team because we're working on a big project for a legal data bank. And he said, the AI expert, he said, well, that's difficult in your field because you need so much expertise to interpret the law and define what a good and a bad law is. And if you define good or bad, is your result of what this law ended up doing in practice useful? And then did you have other factors that impact that result? So that conversation was really complicated, but it was interesting, but because it said that's specific, the law really requires a lot of expertise, which makes it a specific challenge for AI development. So we'll see where it goes, but we're still needed, I guess, legal experts.
Thank you to both of you for this really inspiring debate and your presentations. Unfortunately, of course, we should discuss that until 2 in the morning, but we are already a little bit running out of time. So I would like to really thank you for your presentation, for the debate. I think we need to continue the discussion another time. And I would like to say to all the people that are over there somewhere to have a very good evening. And I think that even if we cannot do that all together, I would like to clap to say really thank you for this enriching debate.
Ciao.
Bye.
Bye.
Bye.